with the judiciary has to be robust, and cyber law shall play a major role to cater the need of the hour. The four core components identified for the proper governance of the whole R board or I board or we board, what we are talking, is the people, the process, the policies, and technology. Yesterday, we have discussed about people and process. DG has, DGCI Professor Mona had given a very good picture of what exactly and how exactly the things are happening and what can happen. Now today, from the policy perspective, I think it's very important to go for the legal part of the whole component. So our first speaker, which is Shri Pawan Duggal, he will be talking about that. The second speaker is Mrs. Neeta Verma. He is Deputy Director General NIC, and she will be talking about from the technological part, and that will be how the cloud can be used, how the other areas can be touched upon. That's what exactly is the today's plan. I'll briefly present the resume of Mr. Pawan Duggal. Shri Pawan Duggal is the president of cyberlaw.net. He is working in the pioneering area of cyber law. He has been an eminent personality in this legal framework for the cyber side and an expert and authority on cyber law and e-commerce law. He is empanelment in the consultant in the cyber law and in the UN and the cyber crime also, that is UNICEF program. The member of AFTEC legal working group, and he is also working in the Council for Europe and Cybercrime and works as expert authority in the cyber law premium ASEAN task force. So a very renowned lawyer in Supreme Court, and cyber law and cybercrime is what exactly his specialization. The second speaker, Mrs. Neeta Verma, has been associated with the induction of World Wide Web Service in the government way back in 1996. She has consulted large number of government departments and their portal department strategies. She has also developed e-governance toolkit for developing nations and UNESCO. She currently looks after overall opportunities in the government data centers set up by the NIC across the country. The NIC has launched first national cloud and government spanning across the national data center to provide state-of-the-art agile on-demand ICT infrastructure to the government department to deliver citizen services. She has guided a team of NIC officers right from the concept, architecture, selection of technology and implementation cloud for Indian government. She is currently leading implementation of open data information and government through data portals, that data.gov.in. She was invited by US government to chair the panel during the International Open Government Data Consortium and by World Bank during IOGDC 2015. So with this, I will request Shri Pawan Duggal, who is joining us through Skype, to present his talk.
Thank you, Dr. Darbari, distinguished speakers on the dais, ladies and gentlemen. This entire episode of internet vote or R vote or remote voting is a concept that will become extremely relevant in the passing times. However, we'll have to quickly address the connected legal, policy and regulatory issues. As a lawyer, let me come straight to the challenges that we have. The first most significant challenge in today's context is how do we ensure the cyber security of our vote or I vote. Today, cyber security has become even more prevalent because the recent Snowden revelations have told us that it's now the business of every state and non-state actor to snoop, to intercept, to monitor. So it's only a question of time before the electoral processes in a country start getting prejudicially impacted or interfered with by state and non-state actors. And to hack into the R vote mechanisms, the systems, and thereby ensure an impact, prejudicial or otherwise, in the electoral process per se. So most of the people are still not valuing the significance of cyber security, but I think in today's scenario, cyber security becomes the #1 legal challenge, apart from being a technical challenge. How do we ensure that the breaches of cyber security in the R vote ecosystem or the network get appropriately addressed by the law? What kind of mechanisms we need to have? What kind of punishments we need to have in case if there is either unauthorized access or illegal misuse of the R voting or the I voting mechanism per se? That's from the process perspective. Seen from another angle at the back end as well, the relevant administrating authorities concerning R vote and I vote have to ensure that they will have to put in place appropriate, reasonable security practices and procedures so as to ensure that their R voting or I voting platform is relatively secure and is relatively protected from unauthorized access per se. Now, when I come in the context of India per se, we have to quickly realize that we have in place in the 2000. This law in the 2008 amendments had come up with a new concept of an intermediary. An intermediary with respect to any particular electronic record is any person who, on behalf of another person, receives, stores, or transmits any particular electronic record or provides any service with respect to that record, and specifically includes network service providers. So in this case, Election Commission of India, despite being a statutory authority, would also qualify to be an intermediary and a network service provider. And under Section 79(2)(c) of the Information Technology Act 2000, these network service providers are mandated to exercise, to recently come up with some rules and regulations which categorically state that these service providers will have to ensure that they put in place reasonable security practices and procedures for the purposes of ensuring that the relevant electronic content on their networks is safe from unauthorized intrusion and from cybercrime. So another important challenge from the R vote or the I vote ecosystem will be the challenge from cyber criminals and cyber terrorists. As cyber criminals are devising new mechanisms to attack democracy, it's but natural to expect that they would also be attacking the R vote system. And now with the advent of the darknet coming in, an already large number of players in India are resorting to the darknet, it's imperative that appropriate legal mechanisms need to be evolved in this regard so as to protect the R vote mechanism per se from unauthorized and illegal activities. Similarly, see from another angle, cyber criminals would want to create terror in the minds of the people. And what better way than to hack into the R vote or the I vote ecosystem and thereby create terror amongst not just the election ecosystem, but the people per se, saying that look, if we have the power to hack into your R vote, we just have the power to mess up with any of your democratic institutions as well. Those issues will have to be appropriately addressed. At the outset, let me share by saying that the Information Technology Act 2000 is not an R vote legislation or an I vote legislation. In fact, it was not even framed keeping in mind the eventual emergence of the R vote or the I vote. However, as we go forward in the terms of making R voting more real and practical scenario, it will be imperative that appropriate amendments will have to be carried out under the Information Technology Act 2000 so as to help promote the legal frameworks for ensuring the further growth. Another important issue that I thought I'd like to highlight will be the legal issue pertaining to ensuring authenticity. Now, the IT Act is still relatively premature. I mean, I can even say it's primitive because it's only talking about authentication of electronic records. But when we are talking of R vote, it's not just authentication of electronic records, it is also going to be authentication of the procedures, practices, and processes which ultimately, cumulatively seen together, would constitute a successful R-voting transaction. So, appropriate issues in this regard will have to be dealt with. Though the law is broad enough to include within its ambit electronic signatures, the fact is, how will these electronic signatures or the digital signatures work in the context of e-voting or R-voting? That's something that will have to be appropriately researched and put the mind there too. Another important issue that I thought will be extremely relevant from the perspective of ensuring a more, shall I say, smooth sail for our vote is what happens to the disputes pertaining to our votes. Where are they going to be adjudicated upon? Would it be normal courts? Would it be special courts? Would it be Election Commission of India? If so, can the Election Commission of India, being the authority conducting the vote, also be made responsible for adjudicating of all disputes pertaining to the vote? I think there are issues pertaining to the conflict with the basic maxim which says that a party cannot be the judge of its own cause. And having said that, we will need to come up with appropriate, effective legal mechanisms so as to provide redress mechanisms available for people in the event they have disputes pertaining to our voting. Another important legal issue that will need to be appropriately addressed is the issue pertaining to jurisdiction. Where would the jurisdiction lie pertaining to our voting? Would it be at the place where the access to the relevant computer network was made? Would it be the location of the physical infrastructure and electronic networks of the Election Commission? And in case of any intermediary services are used in between or outsourced by the Election Commission of India, would the relevant physical location of the office address of the said intermediary to whom services are outsourced be the relevant, shall I say, source or the area on which jurisdiction is going to be exercised? Further, which court will be able to exercise jurisdiction? Would it be a civil matter? Would it be a criminal matter? So somewhere down the line, the Representation of People's Act will have to be appropriately amended, primarily because this was a legislation to promote democracy and electoral systems in the country. However, at the time when it was formed, electronic ecosystem was not even envisaged. Now, with these changes of technology and with new electronic and technical paradigms coming in, I think an absolute urgent requirement of the time is to ensure that appropriate amendments to the information, to the Representation of People Act needs to be also done per se. I also want to highlight to you one important legal aspect that most of the people don't even consider and take it for granted. And this is the aspect pertaining to the evidentiary value of our vote. Where and how will the said our vote be made as legal? Well, technically speaking, our vote is nothing but data and information in electronic form, which has been granted legality to the electronic format by the Information Technology Act 2000. But the fact remains is, recently the Supreme Court of India, in a landmark judgment of Anwar PV versus PK Bashir, has not only gone ahead and revisited the entire existing law pertaining to electronic evidence, but has further gone ahead and laid down the said law. They've actually gone ahead and even overruled the Parliament House attack case and have now said that henceforth, in case if any electronic record has to be produced or proved in accordance with law before any court of law, it can only be done so by coming up with appropriate certifications under Section 65B of the amended Indian Evidence Act as amended by the Information Technology Act. Which means the bigger issue in the context of our vote is going to be who is going to give that certification to say that the our vote is either correct or that the tampered provisions of the our vote or the tampered nature or avatar of the our vote is what is available on my system and this is the output that we have taken. So these are very, very complicated issues. The Supreme Court judgment did not envisage the provisions of our vote when this particular judgment has been given. And clearly the law pertaining to electronic evidence will have to be appropriately reseen and re-looked at in the context of independent India in case if we want to make our vote a complete reality. The fact remains is that our voting has been successfully tested in various jurisdictions, whether it's France, whether it's US, whether it's Germany, whether it is Switzerland, and different places have had different experiences. But Estonia, as a country, has shown remarkable progress in this entire process. They've actually even come up with a committee to deal with electronic voting per se. And this has all happened thanks to the 2007 attack on Estonia by hackers. Those attacks were so severe, and people say the hackers were from Russia, that these attacks virtually paralyzed the complete Estonian economy, and consequently thereto, Estonia realized that it was a sitting duck as far as attacks from cyber criminals were concerned. So it actually launched extensive legal programs and capacity building programs, and today it's one of the cutting edge nations, and of course its work in our voting is also remarkably wonderful as we work forward. I think I would like to also talk about the need for also sensitizing the issue pertaining to compliances of our voting with existing legislation. Good, bad, or worse, your our voting will have data which will be of sensitive nature. Some of the data will also corresponding to personal information or personally identifiable information or even sensitive personal information. So to the extent that appropriate compliances are mandated under the Information Technology Act 2000 and the rules and regulations made thereunder pertaining to personal information and the sensitive personal data, the same will have to be ensured per se by the relevant authorities who would be providing the our voting ecosystem. And finally, I think the entire aspect pertaining to liability of intermediaries will have to have a fresh look in the context of our vote and I vote. Why? Because the Election Commission of India or all its companies to whom it will outsource this process are intermediaries under Section 21W of the IT Act. They are liable for third-party data or information made available in case if they do not comply with the law, in case if they do not exercise due diligence while discharging their obligations under the law, and in case once they are notified of any illegality on their network, they fail to remove or disable access to the same. And finally, if they go ahead and conspire in the commission of any illegal or criminal activity. Now, for all that, it's imperative that the appropriate exposure for third-party data towards potential liability for the legal entities who are intermediaries will have to have a fresh look, primarily because unlike other sectors in e-commerce or m-commerce, e-voting or our voting is a different ballgame altogether. It's part of sovereign functions, and therefore somewhere down the line, provision will need to be carved out in the existing legislation to the effect that there should be complete limitation of liability to the legal authority who is actually conducting the our vote per se. Now the problem is that the Supreme Court of India has recently given its seal of approval to the entire provisions of liability of intermediaries under Section 79 of the Information Technology Act 2000. This is in the famous case of Shreya Singhal versus Union of India. So I think going forward, there are a lot of potential legal challenges that will have to be addressed. These issues will have to be not only thought over, but also incorporated under the law. I think till such time the legal frameworks are not in place, it will not be a good idea to really start the R vote or the E vote, because the success of the R vote or I vote is primarily going to be dependent on two things. One, appropriate legal frameworks that grant legality and legal protection to the R voting mechanism and ecosystem as a whole. Number two, the appropriate enabling technological and technical parameters for ensuring that our vote is a success. So I think a lot of work really remains, but I would really like to compliment CDAC for organizing this workshop on this very important and critical aspect, and I do hope that the appropriate stakeholders, including the government and the Election Commission of India, sits up and takes note of these extremely significant and relevant legal, policy and regulatory challenges that are about to impact or that will always be impacting our voting or I voting per se. Thank you, ladies and gentlemen. It's a pleasure talking to you this morning.
So, any question? A quick one, I think. Just introduce yourself and then.
My name is Craig Burton and I'm from COASCA. Previously I was from the Victorian Electoral Commission of Australia. Sir, I have enjoyed your presentation and I wanted to ask one legal question. In my presentation yesterday, I talked about the law that governs the Electoral Commission. So in Australia we have an Electoral Act for each state and a Federal Act. In fact, these acts have electronic voting in them, and what makes them important is that the Act says there must be control of integrity in the electronic voting system. It's a very broad term, but it has a very important meaning. So the Electoral Act sets a very, very high bar for the kind of voting system that you can use. This, I think, is relevant to changes in the law that you have proposed here in India. Have you seen this, or have you had time to think about the standards the Act will set for the Commission here in India?
Thank you for that question. The fact remains is that preliminary stages are currently on. We haven't even gone much in that particular direction. The reason for this is, I'm aware of the proposed legislation that you're talking about, but in India, we have a huge challenge. The possibility of doing a cut and paste from a foreign legislation and putting it onto India without customizing it in accordance with the requirements of Indian conditions will have its own practical challenges. This is all the more so since the Indian law specifically talks about reasonable security practices and procedures which are mandated to be implemented and maintained constantly by all service providers, network service providers and intermediaries per se. So let me give an example. The ISO 27001 is one such international standard that has been actually mandated by the Indian government to really denote compliance with the parameters of reasonable security practices and procedures. But I completely endorse the thought process. India needs to do a lot of work because under something the bar is going to be set high. The chances of potential tampering, alteration or manipulation are relatively very high. And given the fact that the dark net is now such a big challenge that it's staring us on our face, and yet the law enforcement doesn't even want to recognize its existence, we are in for huge challenges. I think India can really do very well in terms of taking lessons from legislations like the ones that you mentioned, and then exploring as to how the same can be married to Indian conditions. Why? Because India is the biggest democracy in the world. Our entire sizes on the population and the electoral processes are crystal clearly showing that we need to adopt our own customized approach. Standard approaches which are successful in other smaller jurisdictions may be good case studies, but ultimately India will really have to carve out its own niche. But I completely endorse the thought process. Unless those high bars are not going to be set, the entire trust element to the our vote ecosystem would itself not be put in place.
Thank you.
Thank you.
Anybody else? I think.
Hello, this is Jordi from Sweden. I think that it's quite interesting the fact that there will be legislation to cover the use of IT in the case of remote vote. But what about any other use of IT in the electoral processes? Since also the IT systems are used for managing electoral rolls, for configuring traditional elections. So I think that it's a good point to consider attacks not only on remote voting, not forget the rest of the things, since nowadays we are using IT systems for anything. And I know, for instance, that cyber attacks are already done on traditional systems. In Canada, hackers configure an IVR system and redirect voters from one polling center to another. And when they arrive late, they cannot vote. So I think that we need to consider not only if you are open the door or you are legislating about how to use IT systems on remote voting, I think that is a good moment not only to focus here, since if I'm a hacker, I'm going to follow the easy path. And if I have a robust remote voting system, but a weak, for instance, voter registration system, then I'm going to attack the other. So I think that in this case, it's important to consider everything. And nowadays, even the postal service is using computers. So everything is vulnerable from this point of view. So I think that it's important not only focus on remote voting, but to think about everything that is based on or that is using information systems.
Thank you. In fact, thank you for that question and thank you for your perspectives, which I completely endorse. Since you were talking of our work, I was focusing on those aspects. But today, even in actual world systems, we are using computers, computer systems, computer networks, computer resources, and communication devices. And therefore, ensuring its the protection and preservation of its security and related aspects, including the aspects pertaining to intellectual property rights, as you mentioned, are extremely relevant. So India, like any other nation, will have to sit up, take notice, take a holistic approach, not just for our voting in the internet ecosystem, but general voting per se, and look at the entire mechanism to ensure that this mechanism does not really open up doors of potential misuse. Well, we would be opening up doors, but prior to opening up doors, it's time for national governments to sit back, think, do homework, and ensure how your doors are going to be protected and how the interiors of your home are protected from unauthorized access and illegal activities. But thank you for your perspectives, and I completely endorse your thought process. Thank you.
So good. I think I'd like to thank Mr. Pawan Duggal. And I think it is a time when we will be consulting you and taking your inputs for the next level. Thanks a lot. And since you have to leave for the Supreme Court, I'll not hold you back, and I will continue.